Therefore, lawyers are meant to be unofficial judges. In most of the matches on the playground, the players themselves know which side has won. Only in rare cases, the services of referees are required to formally certify the victors. Similarly, officially appointed judges at the expense of taxpayer ought to be required only in a minuscule percentage of cases, as the greater part of adjudicatory function ought to be discharged by informal judges called legal experts. Therefore, lawyers are meant to be problem solvers and not problem creators. After the trial is concluded and before the arguments are advanced, both the lawyers know their respective cases, and if both are honest and efficient, they can arrive at a consensus, obviating the need for official judge to give his formal judgment. Now I am going to show you. Here is the sketch of the ideal judiciary which I contemplate. Now, this is the foundation, as you can see here, and the above is the superstructure. Predictability of judgments forms the basis for the superstructure. Predictability will result in instant conversion of all diligent lawyers as judges of the private sector, who play inquisitorial, that is to say, investigative role. Judges and juries paid by the state will step in only to act as referees in adversarial courts when private sector judges, that is, advocates, disagree. This is alternative dispute resolution, ADR. When judges also disagree, majority prevails. Adding to the judge strength and improving their caliber will definitely help. Integrity of lawyers and judges is an additional requirement which depends upon the general prosperity of the profession and salaries of judges. Here I may add, ensuring universal basic income, which is the modern concept, will help many lawyers to support themselves when there is need, so that they don't stoop to below the normal acceptable levels of conduct. In criminal cases, as questions of fact predominate, reintroduction of jury trials and strengthening the investigation prosecution machinery will ensure predictability, paving the way for plea bargaining, resulting in a major portion of criminal cases being settled by this procedure within a month or two after the filing of the charge sheets. In the US, more than 90% of criminal cases are settled this way. Once the public realize that there is no delay in disposal of cases, the total volume of work for lawyers would increase, resulting in a win-all situation to the legal profession, raising its general prosperity and ensuring the rule of law to the society. Then coming to civil matters, here in the inquisitorial role of lawyers, facts gathered by advocates by voluntary disclosure. About 20% of cases are settled at the stage of consultation and exchange of notices in lawyers' chambers. So usually it takes about 1 month and both the advocates get paid. It's a win-win situation for the advocates. There are no losers here. Then, if this stage is crossed and if the matter is not settled, then the matter goes to court. At that stage, facts are accessed by advocates by employing the judge's coercive power. For example, 70% of the cases get settled by lawyers by consent after discovery and inspection under Order 11 CPC. The Order 12 also is relevant. Both the advocates get paid proportionately. It's a win-win situation for advocates, and cases are disposed of in 3 months. This could happen in about 7